Hello everybody and welcome back to the Law Academy podcast. In this episode we are talking about critical legal theory, and this is something that I threw out there on a poll. I didn't actually expect it to get the votes that it did when we were comparing the other options. The other option you could have had that seemed to be winning out as well in this poll was a discussion about social media and the concept of freedom of speech on social media and the kind of arguments for and against both of these positions. So maybe I'll do that at some point, but it was very clear to me that nobody wants to see any more Russia-Ukraine news, which is fair enough. You know what? I understand. Instead, we're going to talk about critical legal theory. So, critical legal theory, as a very brief introduction, is a branch of jurisprudence, quite a modern branch of jurisprudence that emerged out of the 1970s. And we're going to go through in this episode briefly what the broad tenets of critical legal theory are, look a little bit at the history of critical legal theory, examine the distinction between critical legal theory on the one hand and the emergence of American realist jurisprudence in the 1920s and 1930s on the other hand. And then we will talk about the intersections between critical legal theory and other jurisprudential theories, things such as Marxism, and also the distinction between a critical legal theory and their rejection of liberalism, and also the ways in which American realism supports liberalism, or accepts liberalism into its heart, and the distinction between the two. So, really, we have looked at different philosophical positions relating to the law in previous actual lessons. We have a whole series of lessons dedicated to jurisprudence. We've talked about natural law, we talked about legal positivism, we talked about Dawkins' critiques of legal positivism. We also talked about law and society, sociological implications of the law, and Marxist interpretations of the law. And so, this is nothing new on the Law Academy channel. We talk about law and we talk about the philosophy of law all the time. But we're actually going to talk about a more controversial aspect of the philosophy of law. And the reason why it's controversial is not because in any way that it is somehow ascribing positions that are in any way radical necessarily, but just because people, mainly in America, decided to take the concept of critical legal theory, specifically take the concept of critical race theory a few months ago, and run with it as far as they could, and espouse all kinds of nonsense about what this actual tradition is, and effectively just shout, "Think of the children." Imagine teaching children such a radical theory of society. Of course, in reality, it's a lot more tame than that. There's not really much to it, and it seemed to blow my mind just how much people on both sides of the political spectrum, both the left and the right, didn't have a clue what critical legal theory was. So, put simply, I'm going to begin by just putting simply, critical theory takes what is assumed to be that at the heart of jurisprudence, okay, and looks through these things through a modality of lenses. So what do I mean by this? So we take what is assumed to be the heart of jurisprudence. Well, according to some people, specifically feminist interpretations of the law, the heart of jurisprudence is fundamentally patriarchal hierarchies, the patriarchy. According to a critical race theorist, we would say something like race and racial inequality and systemic oppression is something that exists at the heart of jurisprudence. We take these things and we examine the modalities of law through these particular lenses. So it means that critical legal theory doesn't necessarily have a single unified tradition. Instead, it represents a broad tradition which cuts at intersections between a number of different lenses. Some critical legal theorists place too heavily or more heavily an emphasis on the concept of patriarchy and look at it through a feminist lens or even a radical feminist lens. Others take a look at it through a racial oppression lens. And neither of these views are necessarily worse than one another. There's not one that is correct. There is not a correct view to look at the law. These are just what we would describe as lens of analysis, modes of analysis, ways in which we can look at different things. And there's not necessarily anything wrong with that. But it just means that critical theory is quite a broad tradition rather than something that is single and unified. And so the purpose of critical theory, in its broadest sense, is to contest the universal, rational foundation of the law. Critical legal theory also rejects the view that the law and the existence of the law is somehow something that is separate from the rest of society. The law the law isn't and never can be independent from politics, morality, economics, linguistics, literary criticism, philosophy, any of these different things. And this shouldn't be controversial in the slightest. Nobody should be analysing law and legal traditions through just a single unified lens of just the law. The law is separate from everything else. The law is something that has developed through society. The law only exists because society exists. That is something that a sociologist of law would argue. Law isn't something that is wholly separate and distinct from society. It is made by society. It is made by politics and economics and social relations, and it incorporates things such as morality and ethics and philosophy. So it's important that we don't just look at the law as this thing that we can separate from everything else, which is why that if you're a student studying law, it's always important, in my opinion, to not just study law, but to also try and go a little bit outside the box, talk about and read some more philosophy, read some history, read some economics, etc., etc., etc. It gives you a much more holistic interpretation of the law and a better way of viewing how law operates in society. One aspect of critical legal theory, which is particularly important, is something called the concept of determinacy. And the critical legal theorist would argue that, far from being determinate, the law is instead uncertain, ambiguous, and unstable. And we're going to get onto this in a little bit more detail a little bit later on when we look at the ways in which we can operate in a society seemingly with the understanding that law is determinate and it is necessary and it is objective in nature, but somehow in reality this is just a lens that we view it through, and we're going to draw on some Marxist interpretations of that for our analysis. Instead of operating in an objective sense, guided by principles such as rationality, the law is in fact a method of upholding political and economic relations in society. Again, instead of examining the law as a separate entity, as a separate thing that is not anything to do with politics or economics, it is in fact not only something that is incorporated into politics and economics, but it upholds political and economic relations. It upholds political and economic power within society. Moreover, according to the critical legal theorist, the law is neither neutral nor objective. Again, taking what we traditionally understand, the traditional understanding of what the law is supposed to be, taking the normative claims of what the law ought to be. It ought to be objective. It ought to be transparent. It ought to be predictable, as in we should know, if we know the basic principles of the law, we should know what the basic outcomes of particular cases should be. It takes all of these views and turns them on their head. It is not neutral. It is not objective. Ideas such as equality, justice, and the rule of law are simply fictions that the law employs to make sense and to make a sense of perception of neutrality. So while there is a perception of neutrality, there is a consciousness that exists in relation to the way in which law operates. People perceive the law to be neutral and objective, and perceive ideals such as equality, justice, and the rule of law as being integral to the legal system. They are in fact fictions. They are in fact perceptions. They are in fact illusions. if we think about the history of critical legal theory, it is a doctrine of jurisprudence and began in the United States in the 1970s. And it was a broadly leftist tradition. I think those who are well-versed, or at least somewhat well-versed, with the basic political philosophy would understand that this is definitely a broadly leftist tradition already. We would understand that to be. And it came out of the 1970s, out of the emerging Cold War antics of United States foreign policy. Of course, being a leftist in America in the 1970s wasn't entirely the most safe thing to do, especially just because we've come out of this period of McCarthyism and the Red Scare and the idea of the communist under every single, around every single corner. But we still see this doctrine of jurisprudence begin to develop, and in its most traditional and original format, critical legal theory had three distinct features to it. The first feature was that it was a tradition that was firmly situated as a legal tradition. This is something that is quite important, because other modes of analysis for the law tended to stem from traditions of politics, political science, political theory, or sociology or sociological studies. But instead, critical legal theory takes the view of the law from a legal perspective, okay, and it starts to analyze that law from that perspective. It uses the law as a starting point, if you will. The second feature is that because of this first feature, it therefore sought to identify and call out injustices that are within the legal doctrine itself. So instead of looking at the law as some unchanging, objective reality, this omnipresent, omnipotent reality that exists separately to everything else, and that if there are injustices that arise, they don't arise because of the law. Instead, we look at the injustices that are actually within the legal doctrine itself. We analyze the legal doctrine in and of itself and look at injustices that exist and are represented from it. The third feature is that it represented itself as an approach that was both intersectional and interdisciplinary. We've mentioned this already. It drew on traditions of politics, literary criticism, philosophy, economics, and linguistics. And I think, personally, I'm not a critical legal theorist, personally. My philosophy of law is... I'm not actually quite sure where I'd actually land on a particular legal philosophy, but I do accept very, very strongly the view that you shouldn't ever just understand the law as something that exists within one field. It shouldn't exist within one, as one separate entity that is devoid of any kind of philosophical interpretation, economic interpretation, geopolitical interpretation. And as somebody who's doing PhD research right now, I recognize of and the necessity to not just look at different things from a single legal lens, from a number of different perspectives. I'll give a very good example of where I've done this personally quite recently, is looking at the collapse of the Havana Charter for the International Trade Organization. This was something that came out of the Bretton Woods Conference in the 1940s, and the International Trade Organization was supposed to be something similar to the WTO as it exists today. And in my analysis, I was trying to look at different explanations as to why the Havana Charter ultimately failed. My ultimate aim was to try and argue that it didn't fail because of the inherent failures of multilateralism, but more other factors. And you have to draw, when you're looking at an example of this, quite a specific lens of analysis that I was looking at, you have to draw on other factors. I drew on economic principles, on political ideas, the reason why the Havana Charter was unable to be passed within Congress, whereas the General Agreement on Tariffs and Trade from 1947 was. And I had to word that out, and that looked at a political perspective. I looked at the distinction that began to exist and the geopolitical implications of the emerging Cold War that existed. And then I looked at the emergence of the decolonial period that existed following the end of the Second World War, as well as post-colonial states began to gain their independence as a number of empires collapsed and things like the British Empire began to contract significantly. So these are the different things that, from my experience personally, in this one specific example, I had to rely on, not just law when explaining these things. I wanted to talk about politics, I wanted to talk about geopolitics, and I wanted to talk about the different ways in which, from a political economy perspective, these things operated. So I agree with this third distinct feature quite heavily on this regard. As I've mentioned already, critical legal theory seems to have stemmed partly from the American realist movement. And this was a movement in the 1920s and 30s that rejected the more traditional formalist interpretations of jurisprudence. So principles that were legal positivist in nature, so people like Austin, Jeremy Bentham, John Stuart Mill, these people who were undoubtedly liberals and upheld the traditions of liberalism, were rejected by the American realist movement, because the American realist movement wanted to instead provide a more sociological interpretation of the law, again cutting at the intersection between law and other traditions. The American realists rejects the so-called quasi-metaphysical conceptions of the law, social constructs that bear no relevance to reality, which is hence why we have the name realism. They wanted to get rid of all this kind of wishy-washy metaphysical perspectives of the law, and in quite a famous quote by American realist Oliver Wendell Holmes, they sum up the position by describing the concept of the common law. They state that it is, quote, not a brooding omnipresence in the sky, but the articulate voice of some sovereign or quasi-sovereign that can be identified. So they tried to, in this sense, demystify the concept and understanding of the law. They wanted to get rid of this understanding of the law as some omnipresent, ethereal concept. In reality, it was something that we can see because it was the articulate voice of some sovereign or quasi-sovereign that we can identify particularly. Making clear that the law should be defined by what the court says, Holmes opines that one should not conflate law and morality, famously stating that that we should consider what the law is, not what it ought to be, thus rejecting any kind of normative claims that come with this interpretation. So we can see that we can draw some perspectives and some comparisons between the American realist movement from the 1930s and the later critical legal theorist movement in the 1970s, because they do undoubtedly share some perspectives, but they're in no way should it be seen as a continuation of realism. We shouldn't see that we shouldn't understand critical legal theory as somehow carrying on the work of the American realist movement. Instead, it should be seen as something that may have had some influence, but they still share, and they are still very different and distinct traditions. The critical legal theorist, for example, does not seek to engage in the empirical or pragmatic nature of the law. That's something that is increasingly important for the realist. Moreover, the critical legal theorist ultimately views the law as damaging, problematic, and detrimental in the sense that it reproduces some kind of oppressive nature of social forms. This is obviously the view as they view the law as it exists today, not necessarily as it would always exist. Not every critical legal theorist would make the claim that law in and of itself is something that will always uphold hierarchy and oppression within society. The critical legal theorist, more importantly, as a more important distinction between the two traditions, would reject the distinction that the legal theorist makes between law and other disciplines such as morality and politics. We've seen already that critical legal theory fundamentally believes that law is just politics. Legal reasoning is in no way different from any other form of logical or argumentative reasoning. And then finally, and arguably more important than that point actually, the critical legal theorist rejects the view of liberalism and neutrality of the law. Both of these are things that are accepted by the American realist, but most notably rejecting liberalism. Now, this is something that we start to see as we start to see the 1970s and the American critical legal theorist movement. We start to see embracing traditions of Marxism and Marxist leftist theories of law. which is important to note because from a Marxist perspective, a Marxist analysis of the law, there is a heavy reliance by the critical legal theorist on Marxist terminology and Marxist language to explain the kind of sociological implications of the law. From a Marxist analysis, critical legal theory examines the nature of the so-called hegemonic consciousness. This was a term coined by Italian Marxist Antonio Gramsci, and it refers to the idea that social order is maintained by a system of beliefs which we in a society accept as just common sense, just the natural order of things. And this is what we describe as the idea of hegemonic consciousness. The critical legal theorists will take this view and suggest that there are aspects of the law that exhibit this idea of hegemonic consciousness, beliefs that for some reason people want to just accept as something that is just necessarily part of the everyday life and the everyday order of society. Also drawing from Marxist and Marxist language, the critical legal theorist believes in a process known as reification. And this was a term coined and used to refer to the manner in which ideas become material things. So these material things that exist in society, according to the Marxist, are portrayed as essential, necessary, and objective, when in reality they are in fact contingent, arbitrary, and subjective. And what we are trying to do here is refer to the law in such a way. And I think I mentioned this at the start of this episode, that the critical legal theorist accepts that the most fundamental aspects of the law, things like objectivity, equality, justice, rule of law, these kinds of things are necessarily just a fiction. They do not exist in reality in the same kind of way and understood in the same kind of way as we think. So what we mean by this is there is a reification that is used. Material things that are portrayed as essential, necessary, and objective, like the law, are in reality contingent, arbitrary, and subjective. And this was a way in which, as I mentioned, I said that we're going to explain how society can view something effectively completely differently to how it actually exists in reality. And they draw on these Marxist ideas, the idea of hegemonic consciousness and reification are these terms that are used to interpret the law in the way that they do. They also draw on Freudian analyses of the law. They draw on these things by looking at things such as taking the idea of reification and taking the idea of hegemonic consciousness. They draw on these things and argue as a critical legal theorist that there is an inherent sense of denial that exists as society relates to the law. There is a denial that exists in this process, because denial, according to a Freudian perspective, is a way of coping with contradictions that are far too painful for us to hold in our conscious mind, and we therefore have to deny these realities in any kind of way. So while the law seems to be perceived by society as promoting equality, freedom, and the rule of law, in fact, what it does in reality is uphold oppression and hierarchy. And the only reason why we don't see that is because of these Marxist principles, these ideas of reification and hegemonic consciousness, and then we also draw on the idea of denial, the idea that the law is perceived in this way. It is perceived as promoting equality, freedom, and the rule of law. But in reality, it does the exact opposite, and therefore denial is incorporated as a way of coping with these contradictions. So that's how we can take the critical legal theorist theory and then begin to incorporate the different kind of Marxist and sociological aspects of the law as they're understood. Now, before we finish and finish talking about critical legal theory, I do want to make a mention of critical race theory in a little bit more detail than any other offshoot. And that's just because it's become quite the subject of quite a lot of controversy by namely populist conservative commentators in both the United States and the United Kingdom, to the point that we start to see legislation banning the idea of critical race theory and the teaching of critical race theory to people in certain states in the United States, which is just bizarre, because anybody that understands critical race theory and critical legal theory understands that it is just a lens of analysis, and it is just an offshoot of the broader tradition of critical theory that exists. It'd be like banning, in some sense, a tradition of legal positivism for any particular way. Obviously, we know the reason why this is the case is because of this kind of culture war politics that exists at the moment in the United States and in other countries, whereby actual good policy seems to be set at the wayside, instead of looking at these cultural issues and cultural problems that seem to, well, I say problems, they're not actually problems, but you know what I mean. And so therefore critical race theory is something that's quite interesting, because it is quite conversely one of the most talked about things that happened a few months ago in terms of the broader realm of politics, and at the same time no one knew what it was. You were advocating for it really had any understanding of what it was. It was just a political football that was kicked back and forth to try and deflect from other issues that existed. And ultimately, critical race theory just takes the principles of critical theories and then applies them in a narrow frame of study through the lens of race and racial relations. Now, it's not really for this lesson to discuss critical race theory in any great detail. There are, of course, books, and there are, of course, other more arguably more informed people than me who know a lot more about critical race theory. But there is one interesting part of critical race theory that seems to divert somewhat from the broader tradition of critical theory, and this is the utilizing of what we describe as storytelling and counter-storytelling as a narrative method of, quote, naming one's reality. And so it engages, we see the narrative, if you read any kind of text about critical race theory or utilizing critical race theory, you see that the way in which the prose in which it is written is quite from a perspective of storytelling, and it interweaves the idea of political theory with these kind of shared experiences and quote, naming one's own reality, which I think is quite an interesting way of analysing these different parts and analysing this understanding of social relations and politics. Now, there is one thing finally that I want to talk about, and this is the idea that the critical race theorist takes a, quote, revisionist interpretation, specifically of American civil rights movement and the American civil rights history and the history of race relations that exists in the United States. And this was obviously something that also received a significant amount of backlash by populist conservative commentators in the United States, especially leading up to the 2020 election and the downfall, effectively, of the Trump administration. Because we see that revisionism, as a little side note, the idea of revisionist history isn't something that should be viewed as a pejorative. Now, revisionism, unfortunately, is far too associated with the idea of Holocaust denial, because a lot of Holocaust deniers in the following the Second World War, instead of coming out and just accepting that they were fascistic or that they were anti-Semitic, they decided to hide in this tradition of revisionism. We're just looking at history through a different lens. We're looking at history through this view of, well, really, did the Holocaust happen? Obviously, this is not what we mean when we're talking about revisionism. Unfortunately, that word, the idea of revisionist history, has been co-opted by quite despicable people in society. Because in reality, revisionist history is very interesting. It is a way in which we can go back and look at historical events and see if we can explain them using different lenses. And I think when it comes to the American civil rights movement, there is probably not a another period of history that is necessarily more politicized than the American Civil Rights Movement, because the American Civil Rights Movement can also be seen as something that is ongoing to this day. And so a revisionist understanding of the American Civil Rights Movement is something that is particularly interesting and should be viewed as something that is particularly interesting and worth noting. So that's what I wanted to finish when I'm talking about critical legal theory. Now, in a future episode, if anybody wants, I will go and do more research into critical race theory and do an entire episode on critical race theory if anybody wants to. I don't particularly want to, just because of the dislikes personally, but it's fine. But if there are any other topics anybody wants discussed or looked at through this podcast, this is just a less formal way of discussing these ideas, which I think is quite nice. We will do the social media and free speech episode, because I think that's particularly interesting, especially when we've seen in recent times particularly people being banned from particular social media apps, and the sort of free speech debate that exists in that regard. And then we will do some more other things as well, some other issues that we could talk about, specifically relating to things within international law. So I hope everybody's enjoyed this quite short episode of the Law Academy podcast, and I'll see everybody for the next one.